Hello everyone, good evening and welcome back to LiveLaw Academy. In our previous discussion, we had covered a very recent judgment. Here again, we are now taking you back to another landmark judgment from the previous year related to a very relevant topic. Now, if I show you this paper, this document, what does it remind you of? Electoral bond, right? As you can see it on the screen. Yes, very correctly. We are going to discuss today in today's class, in today's discussion, the judgment on the constitutional validity of electoral bond scheme. So this was a scheme which was introduced by the executive by making certain amendments, which also made certain amendments in different laws, like which we'll be covering also here, RPA, or we talk about the Income Tax Act. And accordingly, we have challenged and we have to assess whether the constitutional validity of this scheme has been upheld or it has been told that this scheme is unconstitutional. So this has been a very hot topic. You must have heard of it also. You must be knowing a little bit about it as well. But here in our discussion, I'll be taking you through the copy of judgment. Okay, so understand what do we do at LiveLaw Academy. We are different here because we show you the copy of the judgment. We do in-depth analysis of the judgment, and we also try to highlight those topics which have been covered in the case and which are relevant for your judiciary preparation. Okay, so this will be a holistic discussion on the electoral bond scheme. Now, you can note down the name of the case here along with the citation. And again, if I come back to the topic, the highlight here is the constitutional validity. So when you see this term, constitutional validity of something, you have to see in essence which provision of the Constitution, which article from the Constitution has been challenged to say that this scheme has to be held unconstitutional. Okay, so the provisions here, you can stop my video and you can write your answer also in the comment section. Which provision or which article of the Indian Constitution were challenged for the electoral bond scheme? Okay, if you do not know, let me tell you, it will be Article 19(1)(a) and it will be Article 40. Now, the question that should come to your mind is that how Article 14 and 19(1)(a) are related to this topic. Okay, so let me just tell you in brief summary. We understand, and we will see this from the judgment also, that there is a nexus between money and political parties. Now, what is that nexus? As you understand, somebody who has financial backing, somebody who can do self campaigning, who can be self reliant during the campaigning process. One perspective of this will be that they will have more chances of being the representative of any political party, right? Secondly, if let's say you are ex-businessman and you choose to transfer or you choose to donate some money to a particular political party, is there nothing that you would be getting in favor or getting in return from them? So there is a likelihood of favor being returned to a businessman who has donated a lot of amount of money to a political party in exchange of the money that he has paid. So this is how first aspect would be that Article 40. Let's say why businessman doesn't have that much of pocket. Now the policy decisions will not be taken in his favor, right? So accordingly, Article 14 has been challenged here, has been considered to be violative by the electoral bond scheme. In very brief manner, I have told you how it can be summarized. Okay, so in a situation where we are able to establish that money is somehow related to or it has a nexus to the working of political parties, in that situation, if you allow one person to have no cap for the donation that he's making, or one particular company to, even though when they have not made a profit in the previous year, they can donate n number of amount of money to you, then in that situation, definitely Article 14 will be violated. Okay, so that can be your primary understanding of why Article 14 was sought. Now, the second aspect is 19(1)(a). Now, we all understand 19(1)(a) gives us the freedom of speech and expression. But within this speech and expression, right to information has been considered to be an important fragment, right? So your right to information is protected under Article 19(1)(a). Now the question comes, because of this electoral bond scheme, was there anything introduced? Was there something that protected or that said that the companies which are making donation do not have to disclose this donation or do not have to keep a record of it? The political parties to whom the donation has been made do not have to show in their accounts the amount of contribution that has been made to them. And if that is so, is that going to affect our rights as an individual, our right to information as an individual in such a situation or not? If yes, then definitely this scheme is violative of Article 19(1)(a). Okay, so what did we understand? Two provisions, two articles from the Indian Constitution when we say the constitutional validity of electoral bond scheme has to be assessed, primarily on the ground of equality, because it is going to affect different people, different companies in not a very different manner, and at the same time Article 19(1)(a), because every person has the right of freedom of speech and expression, and that includes within it the right to information. Okay, now in addition to this, the follow-up question that you may get or you must get here should be with regards to privacy. Ma'am, isn't privacy a concern? The donor is expected to have privacy, right? So in that situation, how can you compel that whoever the donor has made donations for, whichever political party, how can we compel for them to disclose the money that they have paid? Okay, now to get a better understanding of these two perspectives, let me explain it by way of an example. Okay, so let me draw this for you. What happened before electoral bond scheme was that, let's say if there is X person, okay, and if this X person wants to donate some money to a political party, how did they used to do it? They had all the avenues open. They could pay it by money. It was preferable to pay by any of the instruments that are recognized. So it could be by way of DD or check or anything, right? But this electoral bond scheme was introduced with an idea. The executive pitched the idea that we are doing so because we want to promote transparency. Now, under the garb of transparency, whether it has been actually, done or not is a discussion that we are going to do. But it was said that this scheme is going to bring more transparency. And what is happening under the scheme is that X will now go to a particular bank. This has to be a central bank and this has to be State Bank of India only. That is how in the picture also you see the electoral bond shown here is of the State Bank of India. Okay. The other aspect here to be noticed is that it talks about date of issue. It talks about the validity only up to 15 days being there, and the denomination that is mentioned in thousand, right? But it does not talk about the person who has bought the electoral bond. So that is one aspect that you can remember from seeing the picture itself. So when X goes to SBI, he can make the payment in SBI, and he can take the electoral bond with him, which he can later go and submit to the political party. Okay. But this bond will not disclose. It does not disclose the name of the person who has purchased it. Okay, that is the first important aspect which the government proposed, which the government suggested will bring transparency, one, and will curb the practice of black money. So it will not be that people are actually flushing out their black money by making donation. Rather, it is by way of them reaching to the central bank. And in such situation, SBI is supposed to put it on record. So the political party does not get to know about it. The opposition party does not get to know about it. But State Bank of India, because of KYC, will have the record of all the electoral bonds bought from them. Okay. And now accordingly, this is the expected scheme which will curb black money, which will which will promote transparency, and which will at the same time protect this particular X person. Because if in a given situation, in a hypothetical situation, let's say this political party 1 does not win and political party 2 wins. Now, what used to happen before was that when the donation used to be made, it used to be disclosed by the political parties. So the political parties, as per RPA, they were supposed to disclose who had made which amount of contribution to them, right? And therefore the opposition party would know that X businessman has very bluntly supported this political party. Now let's say if this party does not win, what will happen? There are chances of this political party showing certain set of remorse, certain set of agitation towards X, right? So these are all hypothetical situations which have been discussed in the judgment itself. Now, to curb all of this, we say that by electoral bond scheme, when you buy the bond from SBI, and because it will not be disclosed by the political party, this knowledge will never reach to political party too. Okay. So to summarize, this was the primary idea of promoting the scheme. But did it really actually materialize or did it not materialize is a discussion which will follow when we read the judgment. Okay. So this is the primary idea. Now moving ahead, you have to know if you're giving your judiciary exam, this was a very landmark and relevant judgment from the previous year. So you have to know the strength of the bench, okay? And at the same time, you have to know the name of the judges, okay? A concurring opinion has been given by Justice Sanjeev Khanna, which when you read the judgment, you will find is present at the latter part of the judgment, okay? So going now to the issues. Now let's highlight the issues here. If all of this is fine, ma'am, if this is for promotion of transparency, if this is for demolishing the idea of black money, then how did it become an issue in front of the court, right? So this became an issue firstly because we made certain changes and amendments in our laws. Okay, now what are these amendments? Let me show you. These are the amendments that have been made. Let's read it one by one and you will get a brief idea as to whether this appears to be wrong or not. Okay, so let's read it from here. Firstly, section 29C of the RP Act was amended to allow political parties to not disclose campaign contribution received through electoral bond. So the political parties will not have to disclose. One idea is that you want to protect the person who has donated the money to you from the other agitated parties, right? But in such a situation, saying that you will not have to disclose at all, whether it is actually violative or not violative of the constitutional provision is something that we have to understand, okay? Then the other amendment was made in the Companies Act, section 182(3), which was amended to allow companies to not disclose detail of political contribution made by them. Neither the political parties nor the company which is making donation to the party have to disclose this information. Okay. And the third aspect is that the companies which had a cap of political funding, the cap has now been removed. No matter whether you were profitable in the previous year, whether you did not profit in the previous year, everybody without any cap could make the corporate funding. This introduced the concept or fear of shell companies actually making the payment, right? So another fear has been added here by this amendment. And so therefore, even the loss-making companies were in a position to donate by this. And also in the Income Tax Act, we made amendment wherein we said that the political parties do not even have to maintain a record of contribution made to them. So now take a moment. Okay, let me now switch to my English version. अभी तक हमने जो पढ़ा है, आपको इसे देख के क्या लग रहा है? आपको क्या ये प्राइमा फेसी देखने से ही समझ आ रहा है कि ये वॉयलेटिव है या ये ब्लेटेंटली अलग है या रॉन्ग है या कॉन्ट्राडिक्टरी है टू द आइडिया ऑफ कॉन्स्टिट्यूशन? Take a moment, look at all these amendments again and ask this question. The reason I am asking this question to you here is because I want you to think about this, whether this appears to be prima facie violative of part 3, okay, of article 14 of 19(1)(a). ये प्राइमरली ही देखने से रॉन्ग आइडिया दे रहा है, राइट? क्योंकि आपने एक कैप हटा दिया, आपने बोल दिया इवन द कंपनीज which were incurring loss in the previous year, they can also donate, they can donate any amount of money. You are, you are in this manner, you are actually not promoting transparency, rather it is against the idea of transparency, correct? So all these provisions primarily when you read appears to be wrong, and that is a discussion that we will do when I take you to the copy of judgment. Okay, मैंने ये जो आपसे क्वेश्चन पूछा है, this is very relevant, ये बहुत इंपॉर्टेंट है क्योंकि ये ही हमारे कॉन्सेप्ट ऑफ जुडिशियल रिव्यू को आंसर करेगा. सो हम इसमें आएंगे अगली डिस्कशन में जब हम कॉपी ऑफ जजमेंट पे जाते हैं. ओके, now let's go to the issues. Okay, what are the issues here? First issue is whether the non-disclosure of funding to the political parties under the Electoral Bond Scheme violates the voters' right to information. So as I said, Article 19(1)(a). When you say that the political parties will not have to keep any account, will not have to disclose where is the money coming from, which person has made this donation, what contribution has been made to you, क्या ये voters के right to information को infringe नहीं कर रहा है? Yes or no, right? This is the first issue that we have to delve into and find the answer for. The second one is unlimited corporate funding. When you remove the cap and you say no matter what, unlimited corporate funding can be done, will it not interfere with the free and fair elections and equality? So here comes the concept of Article 40, right? Now in this situation where you do not make a distinction between a company which has made profit versus a company which has made loss, okay? An individual versus a company making the donation. In that situation, now doesn't it become violative of equality? Does it also not take away the idea of fairness from the concept of election? Okay, so these are the two primary aspects or two primary issues that are relevant in this particular case, which needs to be addressed. Okay, I hope this is clear. The issues are clear for you to understand what we are going to find the answer for. Now, without taking much of your time, let me take you to the copy of the judgment. So whenever you read from the copy of the judgment, you stop here, you see which jurisdiction of the Supreme Court has been invoked here. So here you see civil original jurisdiction. Now my question to you here is, why civil original jurisdiction? Do you know the answer? Think about it and write your answer. Okay. Now, this is the index of the judgment that we will be referring to, that we'll be summarizing the judgment from. Okay, मैं आपको पूरी judgment में one part, each part पे नहीं लेके जाऊंगी. First, मैं आपको इस judgment की summary दे रही हूँ from the judgment, from the index itself. Okay, आप सिर्फ index को पढ़ के मैं जो समझा रही हूँ उसके notes बना सकते हैं, उसका explanation लिख सकते हैं, and that will cover the entire judgment for your exam perspective. So basically, first we start with the background. We start to see that what was the idea of introducing electoral bond scheme. Okay, transparency, curbing black money, that I have already discussed with you. That the highlighted portion here is that there were certain objections that were raised by ECI and RBI. Before the scheme was notified, ECI and RBI actually highlighted certain concerns to the government with respect to the scheme. All right, and there were certain answers that were given for these concerns, which we will discuss whichever will come to the relevant portion. Okay, so RBI ने बोला आप एक बैंक को authority दे देंगे of and you're introducing a new set of instrument. These bonds that you are introducing is something new, right? So these instruments that you are introducing has to be backed by law and has to be regulated as well, and RBI is the regulatory authority. That is why in return now we chose State Bank of India, one particular bank which is the central bank also, right? So these are multiple contention and objections that were raised by these two statutory bodies. Now after that, we have already understood the issues that are here, for which we need to find the answer for. Now, before we get into the answer of these issues, you can see here this aspect of the scope of judicial review that has been addressed by the court in this case. Okay. Now, why was the scope of judicial review important? I am explaining it to you. You can write your pointers here along with my explanation. Firstly, the court tries to prove, because jurisdiction is being contested, because it is being said that the Supreme Court does not have the power to review a scheme which is based on the economic policy. So the scheme is based on economic policy, and we have plethora of judgment by which we already have understood that if it is a matter of economic policy, the judiciary cannot be reviewing it. Okay. And we also have Article 50 under the Indian Constitution, which very clearly suggests that the executive and the judiciary roles have to be separated, right? So therefore, the judiciary should not be doing so. And that is when the court gets into the issues. The court says that when we talk about no cap on contribution, is that something related to the economic policy or the electoral policy? This is related to the electoral process, right? And therefore, you cannot really say that it is merely a matter of economic policy. So both the issues very clearly depict that these are related to electoral process for which the judiciary can do the review. Okay, so that is what you see here when we go to the judgment also, how it has been answered by the court. Okay. This is exactly something that I've told you. Now, the second aspect of it is related to the scope of judicial review. If this is not related to economic policy, and if this is electoral policy, then definitely judiciary can do the review. Now, what will be the scope? So here the court says, and the court acknowledges that we understand whenever you make changes in the law, the primary presumption is that it is constitutional. Okay. So यहाँ जो भी amendment किए गए हैं, जितने भी laws में amendment किए गए हैं, हमने primarily presume किया कि ये constitutional है. But when you read these amendment, ये क्या ये प्राइमा फेसी रीडिंग में ही आपको अनकॉन्स्टिट्यूशनल अपीयर हो रहे हैं? Yes, right? That is what I just told you also. That if you take a moment and if you look at your screen, you will get an idea that these amendments appear to be going against the idea of constitution, demoting the concept of transparency, right? Taking away the right of equality from people. So that is why the court here says that these primarily appear to be violative of Part 3 of the Indian Constitution, and therefore we have the power to do judicial review in this particular case. Okay, so that is the aspect of judicial review, how the court has tried to answer this question. Now moving to the next part, that is the reply that the court has tried to give for right to information of a voter. Okay, so these are more than enough for you to maintain your summary or to maintain the summary of your answer, wherein we talk about the scope of this, whether voter right is there, whether voter has, the focal point is candidate or it is a political party. So let me just summarize this for you, how the court has answered this aspect. The court acknowledges firstly that how right to information has come into picture. The right to information has come into picture by different precedent, and also when you refer to these two landmark cases, the court says that even with regards to the concept of political equality, or with regards, for example, for us to know the antecedents of a political candidate, अब हमें पता है कि उस political candidate का criminal record है या नहीं है, right? You can simply understand that, you can simply get the information by your control search. So that is why this has been allowed by these judgment, keeping in mind that it forms within the purview of right to information. Okay, so court ने इसको acknowledge किया that हमने पहले right to information को establish किया है, उसको establish करने के बाद हमने acknowledge किया है कि political parties, political candidates की information जो है वो कैसे right to information से related है. Now moving ahead, then the party and the court has held here that we also have to see that whether the focal point is only candidate or does it have to be political parties also. And therefore the court here analyzes constitution, the constitutional amendment debates, and then the court here says that we do acknowledge political parties also. Simple as the concept of symbol of a political party, that also has been introduced because of the constitution, right? Therefore the focal point is not only the candidate, but it also goes to the political party. And us disclosing the information or the political party to mandatorily inform where is the contribution coming from does fall within the ambit of right to information. Okay, so that is how the court has tried to answer these three aspects. And the court says that political funding definitely is important or is an effective exercise for choice of voting, because we have established an association between politics and money. Therefore, this disclosure of information becomes very essential and is an effective exercise, okay, for people to know who they are voting for, where is the money coming from, where is the finances coming from for that political party. It does fall within the ambit of the electoral financing, and it does fall within the ambit of Article 91A. Okay, I hope this much is fine. So by this part, just a second. Yes, by this part, the court has tried to establish how 19(1)(a) covers right to information related to political funding. Moving ahead, the court then talks about that whether right to information is justified for this particular aspect, for saying whether electoral bond scheme is right or not. Now we get into the nitty-gritties of seeing the right of a donor, right of privacy of a donor, and accordingly try to balance it. Okay, so what has happened here is that the court has first read 19(1)(a). They established 19(1)(a), and then they say that 19(1)(a) can be restricted by 19(2). The restrictions that are given under 19(2), correct? And 19(2) lays down certain restriction which includes public order. And that is why you see all these headings that are mentioned. First, curbing black money, that is the idea of right of information. If when one person's voting interest, who they are actually making the contribution for, will be disclosed, yes, it will definitely it will have an impact, or it will have a bridge between the right of information of the other. But is that really justified or not is being assessed here. So first we have to see whether curbing of black money will really happen or not. So the court has done the test of proportionality here. Okay, that is so mentioned here, double proportionality. And the court here tries to balance and see. Let's say X person has a right to privacy, yes. But if this person's financial contribution will not be disclosed, financial contribution will not be disclosed, why businessman will get affected or not? Definitely. Here, the court has acknowledged that if any contribution is made for rupees 20,000 or less, you do not have to make disclosure, okay? But if it is more than 20,000, then in that situation, it becomes essential for you to disclose that information to the public, okay? Because let's say when X person donates, makes financial contribution to political party 1, later political party makes changes which favors X's business. In that situation, don't you think it will be important and it will be very much relevant for this information to be disclosed to public, for them to know whether this decision, whether this policy change was done to favor X or not, right? It is important. Therefore, when we apply the test of proportionality, we understand and we see that it will be better and we will be weighing in favor of this party if we actually will be weighing in favor of the public at large if we actually make the disclosure of the financial contribution makes by the donor. Okay, so that is how balancing the right of information and right of informational privacy has happened here. And then we have understood the double proportionality standard, and we try to see that how we can actually balance in such a case. Okay, so the balance will be done when you allow the contributions to be made. The court also gets into the factual matrix. The court says that more than 97% of the contributions are for more than ₹1 crore. Therefore, all these people have big pockets, all these people have the authority, have the position to influence, and therefore it is very important for us to know if or when are they actually influencing that position that they hold. Okay, so this is how the entire answer with regards to the second issue has been answered by the court. Okay, there are various other points that you can refer to when you read the judgment. I will just do a summary of it and I will show you those as well. Okay, now the third leg of the discussion is with regard to unlimited corporate funding. The court gets into the aspect of or the assessment of Article 14, and the court says that this very clearly on the face of it, it appears to be arbitrary. It also extends to how the money is disposed of. Okay, and we from our own preamble, we protect the idea of political equality. There should not be political inequality. We also, and how political equality is protected: one person, one vote. Okay, keeping certain the seats that are limited are based on the geographical area, on the population. So all these suggest the idea of promoting political equality, and that cannot be taken away by these quid pro quo amendments or arrangements. Okay, so if one person is giving you something, you in return also give a favor to the person. Okay, that can be quid pro quo arrangement, which we are here highlighting and which we are here saying that it should not be so then allowed for the same. Okay, so that is how the court has answered this also. Let's say if you refer to this, if any company has not made any profit, there is no statutory cap. Now you just simply say that any loss making company, any other company can make the contribution. So this also is violative of Article 40. Okay, the ability of a company to influence any electoral process through the contribution is much higher as compared to that of an individual, and that is why companies have been primarily dealt here. The amendment made in Companies Act has been primarily challenged in such a situation. Okay, so this is the summary of the electoral bond scheme, the judgment that has been given. How court has said that all these amendments that have been made are violative and are unconstitutional. These not only violate 19(1)(a), also violate Article 40. Okay, so when you say unlimited corporate funding, that is arbitrary and that is violative of Article 14 as well. And when you say that these disclosure do not have to be made, that also is violative, and therefore the court has given certain directions in this particular landmark judgment. Okay, so I would then take you to the summary of the case from my document here. Firstly, that I have already shown you the decision of the Supreme Court from the direction and the conclusion part. Now, if you have to write in your answer, you can definitely keep this summary in mind. First, you start with judicial review, then you get into close association of politics and money, and you try to establish that. Then you establish that a voter has right to information, but we have to balance this voter's right to information with the other person's, that is donor's right of privacy. And when we balance, we see that the maximum interest of public has to be protected. That has been done keeping the test of proportionality in mind, and we have to find the legitimate goals. We have to find the suitable means of actually coming to a solution. Okay, then we have to see whether curbing of black money is really happened. So the court in this case said that we have to compare whether this is the best possible means. So they actually have assessed that we already have the process of electoral trust, which promotes more transparency, and if we have a better solution, then in that case the idea of electoral bond scheme can definitely be negated or can be accordingly shunned by the parties or by the executive. Okay, and that is how the directions have been given by the court in this situation. Okay, so this is the summary of our today's case law. I hope this has helped you. If you already had studied this point, this has helped you in revising of your concept. If not, I hope this has helped you identifying the different constitutional provision, understanding that what has been the way of giving answer, negating these points, by way of certain tests that has been there but now has been used again here. Multiple precedents and judgments have been used in this particular case. If you have time, you can definitely refer to the copy of the judgment and try to identify now with the background that I have set for you here. Okay, I'll be seeing you again with another recent judgment. In the next class, we'll be covering another recent judgment. And that is how we keep a balance of both landmark judgment from the previous year. We do not cover landmark judgments throughout, okay? We are covering for your judiciary classes, for your judiciary preparation, the landmark judgment from the previous year, okay? And then we also keep switching to the recent judgment, which are relevant for your judiciary examination. So I hope this has been beneficial. If you have any doubt, you can definitely drop your doubts in the comment section. If you want us to cover any case law, you can definitely leave your feedback for that in the comment section as well. Okay, I have, in my sincere effort, I have tried to summarize this judgment in keeping paucity of time in mind. Accordingly, I hope you find this beneficial for yourself. Thank you so much.